A $3.5 million defamation lawsuit brought by Councillor Bill Armstrong against a local radio station and 4 of his political rivals has been tossed out by Ontario's highest court. A decision released on Thursday from the Ontario Court of Appeal made this decision clear. Essentially, the judges in this case decided that Councillor Armstrong didn't suffer any damages as a result of on-air comments, social media comments, and an online story from the radio station that discussed his 1987 sexual assault conviction. He's long ago been pardoned for that conviction, by the way. So we'll just read a couple of comments from the decision here from the Court of Appeal. Very interesting case that looks at the balance between freedom of expression and a person's right to defend their reputation from defamatory comments. So the judge, Justice David Doherty, wrote that the public expects and benefits from vigorous debate among candidates. The rhetoric can become personal and overly zealous. No doubt candidates have in the past and will in the future step over the line between strongly stated opinions and defamatory comments. Here's the great part though, and he talks about new legislation. It's called an anti-slap law, and that stands for strategic lawsuits against public participation. And those are lawsuits that are often used to silence critics or suppress public dialogue that may be unfavorable. Anyway, so the justice here writes, however, the message to be taken from this anti-slap law is that not every foot over the defamatory foul line warrants dragging the offender through the litigation process. So Armstrong will have to cover the legal costs of Chorus Entertainment, which owns 980 CFPL, and his 4 political opponents, which include Ward 2 challenger Nancy McSloy. She ran against Armstrong in the 2014 race. Her husband, her campaign manager, and a political ally who did some canvassing for McSloy and made some comments on social media.